Good afternoon. I'm Diane Kenty. I teach alternative dispute resolution and the mediation practicum here at the law school as adjunct faculty, so delighted to see students from those courses here, and thanks to all of you for attending, and thanks to the Sports Law Society for sponsoring and for pizza, which I see many people are enjoying at the moment. So the case NFL versus the NFL Players Association and Tom Brady has drawn just a little bit of interest this year. It's not often that arbitration proceedings dominate the sports news and are front and center in the national consciousness for months on end, but this case has certainly gripped New England and stayed in the national news all year. The primary focus at the beginning, last January, of course, was the inflation of footballs and whether the New England Patriots or any of their employees or Tom Brady had knowingly and intentionally underinflated footballs below the standard approved level of inflation. And those footballs, before a particular game, the AFC Championship game, had already been inspected. And they were found later to have a lower level of inflation, hence the moniker Deflategate that came to stand for this controversy. So this year first saw an investigation, then disciplinary proceedings, then an arbitration, and then a move into federal district court. And the federal district court judge issued a decision in September. That's now on appeal to the Second Circuit. And the NFL has already filed its appellate brief, which is available online. Actually, all these documents are available online. And the Brady team is due to file its appellate brief in the Second Circuit in early December. So this controversy really has it all: celebrity, science, a lot of money at stake, collective bargaining and union issues, a booming professional sports league that last year is estimated to have $12 billion in revenue, and involvement of high-profile members of the legal profession, sensational journalism, possible motives of envy and revenge at play here. Not to mention a highly successful quarterback and coach who managed to win a Super Bowl in the midst of all this. So today our focus, however, is on the legal analysis and the legal proceedings, not the PSI level of footballs or Tom Brady's cell phone or some of the other juicy aspects of this controversy. So as they say on sports talk shows, we have an excellent panel here to break it all down for us. James Spizuoco, who is a member of the class of 2016 and a graduate of USM, and Trevor Savage, who's a member of the class of 2017 here and a graduate at Emerson College, both of whom are writing on this case. Paul Greene, who's a graduate of the law school, now principal of Global Sports Advocates in Portland, who also teaches sports and entertainment law here at the law school. Linda McGill is regrettably not able to be here today, but fortunately Ian Freeman has stepped in, so we appreciate that. Ian is also at the law firm Bernstein Shur in Portland, and typically represents management in labor and employee matters. And although her clients are primarily public sector employees, she has worked in the private sector as well for VIW and sat across the table from VIW bargaining unions, so she's very familiar with collective bargaining agreements. And Mike Ryan is an arbitrator who brings about 30 years of experience in arbitration and labor relations, and who's a member of the prestigious National Academy of Arbitrators. So thank you all for being here today. Important disclaimer, most or all of us are Patriots fans. So we're not pretending to look at this with a neutral and impartial eye. We do bring a bias here, and I think we acknowledge that if this panel were taking place in Bloomington, Indiana, or New York City, or at the University of Miami, that might look different to us. So the fact that we're here in New England inevitably colors our view of things here. First, James is going to review the factual and procedural steps and various aspects of the NFL collective bargaining agreement. So review the stages of this dispute that led to arbitration and eventually into federal district court. And Trevor is going to discuss judicial review of arbitration and the specific findings and rationale of the federal district court judge's decision in the case. Then I'll have a few questions for the panel, and we want to hear your questions and have an open Q&A as well. So James, why don't you start us off?
All right. It's like a press conference. They're a good football team. Diane, I think you did a good job covering the factual background. Just a little bit more information. So there were the deflated footballs. January 18th is when that story broke. January 23rd, Roger Goodell made a statement that there was going to be there was an ongoing investigation that would be headed by Ted Wells, hence the Wells report, and Jeff Pash, who was an executive vice president of the NFL. May 6th, I think that report was released. Shortly after, there was a 4-game suspension. NFLPA appealed on behalf of Brady. There's all kinds of motions that were written after, all of them denied by Goodell. Eventually, it got to the hearing in June, and then the decision was brought down in July, and then it was appealed. So the starting point for all this, though, is the CBA in the role of commissioner of discipline. I think it's important to understand what exactly a commissioner is and where the commissioner office came from to understand the sort of power dynamics in play. The first commissioner in any professional sport was in baseball following the Black Sox scandal in 1918. It was U.S. District Judge Kennesaw Mountain Landis, which is also the best commissioner name of all time. He was appointed by the MLB, and he said he would do it on 2 conditions. The first, that he is the only commissioner, wouldn't be part of a commission panel. And the second, most importantly, that he would be able to punish players to protect the best interests of the game. And that is the key language that you see for all commissioners in any professional sport. On the NFL, it's conduct detrimental to the integrity of the league. That is the role of commissioners, to protect the integrity of the league. That's what they take seriously. In football, that is Article 46 of the Collective Bargaining Agreement, Commissioner Discipline. It's part of the CBA, so it was, it's collectively bargained. It was negotiated at arm's length. That said, it seems like the NFLPA, the Players Union, did not do a great job on that. It invested an incredible amount of power to Roger Goodell, really unchecked authority. He is the only person who is allowed to levy a suspension for on-field conduct. That's not a personal foul, that's just a little flip. For on-field conduct or conduct detrimental to the league. There's, of course, a notice question involved in that. What is conduct detrimental to the league? Short answer, what Roger Goodell decides it is. It's not spelled out in the CBA. It's not spelled out in the player contracts. There's an NFL conduct policy. It's defined as anything that risks the integrity of the league, so it's not helpful at all. So that all falls on Goodell. There's really no checks by the NFLPA. The only really check on his power is that for suspensions or fines greater than $50,000, he has to consult with the NFLPA, which means nothing. He doesn't have to take the recommendation. The NFLPA has negotiate a schedule for fines for some conduct. So there's fine amounts that are fixed in place. However, Roger Goodell also has the authority, when these circumstances warrant, to increase fines or suspend. Again, no definition of what that is. Which then brings us to the appeal process. In every major sport, there is an appeal to an independent arbitrator. There's different ways to get there. Sometimes it has to be a threshold suspension, can then be appealed. NFL, no such thing. The appeal is in front of the commissioner or his designee. So the commissioner, whoever the commissioner chooses. There's no independent arbitrator, which is why I think it was interesting. And impartiality was not really touched on the decision. So everything goes to Roger Goodell. There are discovery rules. Well, there's a discovery rule for this hearing, and that is that any exhibit somebody plans on using, they have to produce to the other side 3 days before the trial. And that is really the only process that's described at all. So you can see how there's a lot of room for the commissioner to really steer an arbitration like this punishment, and I think that's what got us to where we are today.
Thank you, James. Trevor?
Sure. Can you all hear me? I don't think I need to use the microphone. Okay. So judicial review of arbitration awards are necessarily limited. That's for at least two reasons. The first is to ensure that the ADR process, alternative dispute resolution process, can continue and kind of do its own thing separate from the courts. The second reason is that judges and courts are typically very hesitant to flip arbitration awards simply for the fact that they could very well become inundated with requests to do so should they get too invested in doing that. So that being said, there's a specific statute under defining judicial review or arbitration. I'm going to read it word for word because I think it does help. So I'm going to look at my note for a second here. It's that there can be courts are free to vacate awards if arbitrators are guilty of misconduct in refusing to postpone the hearing, refusing to hear evidence pertinent and material to the controversy, or other behavior by which the rights of a party have been prejudiced. So at the same time, this is both very limited, but also gives the judge some degree of latitude in determining what evidence pertinent material is, so on and so forth. So in Judge Richard Berman's decision vacating Tom Brady's suspension was on 3 grounds. First, that Goodell's award did not draw its essence from the collective bargaining agreement. That when an arbitrator is resolving disputes from a collective bargaining agreement, it's confined only to interpretation and application of the agreement itself. So you might have heard this phrase in the news quite a bit. The arbitrator is not free to dispense their own brand of industrial justice. All awards, all decisions coming from the arbitrator must have been at least drawn from the essence of the bargaining agreement itself. And so the term in this case is the law of the shop. Berman found that Goodell violated the law of the shop because the law of the shop requires advance notice of specific discipline for specific conduct, and that Tom Brady could not have possibly had notice of the discipline for games that he would receive for the specific conduct that he was accused of, alleged to have engaged in, general awareness of others' wrongdoing. We should note that the latest Supreme Court precedent regarding this is that an arbitrator's award must be upheld so long as they are arguably drawing the award from the CBA. So Berman essentially said that Goodell was not even arguably drawing his 4-game suspension from what was collectively bargained for. The second ground for vacation was that Goodell's denial of Brady's motion to compel the testimony of NFL Executive Vice President Jeff Pash was fundamentally unfair in violation of the Federal Arbitration Act. He said that Brady was prejudiced by not being able to cross-examine Pash. And as James said, the CBA doesn't provide for a scope of compelling witness testimony, and so Goodell claimed that that was in his discretion, seeing as the players' union had not bargained for anything greater. And lastly, Berman found that Goodell's denial of Brady's motion to compel or to produce investigative files was also fundamentally unfair in violation of the Federal Arbitration Act. He said that prejudiced Brady being unable to understand and challenge the NFL's factual conclusions. So that was really Judge Berman's decision in vacating the award. It's also important to note that it was not a vindication of any of Brady's wrongdoing. It did not clear Brady from having allegedly deflated or told others to deflate any footballs. Rather, it was a condemnation of the process that the NFL engaged in.
Thank you, Trevor. So backing up a little bit here to the arbitration process that James briefly reviewed under the collective bargaining agreement. Paul, how does the NFL's procedure differ from procedures that other professional sports leagues use?
I'll get to that in a minute. I just want to say I'm proud of Trevor and James. They did a great job explaining all that, and the law school should be proud of the job they're doing. Okay, well, I have it here. This is the NHL collective bargaining agreement. It's Article 18, and as James said, in arbitration in the NHL is reviewable by a decision by Commissioner Bettman is reviewable by a neutral arbitrator. That neutral arbitrator is collectively bargained as part of the process. The NHL and the NHLPA agree on a third party.
So you're talking about the National Hockey League.
National Hockey League, sorry. I assume everyone would know NHL in New England, but National Hockey League. All right, so here's the review. The standard of review in cases of commissioner discipline for off-ice conduct, which is pretty much equivalent to what happened here, shall be whether the commissioner's determination was supported by substantial evidence and was not unreasonable based on the following considerations: the facts and circumstances surrounding the conduct, whether the penalty was proportionate to the gravity of the offense, and the legitimate interest of both the player and the league. So it's a lot less of a deferential standard than in federal court, and certainly gives the arbitrator the opportunity to look at the decision by the commissioner and either flip it, lower it, or decide independently that it wasn't a proper decision. So there is a lot more play in the joints there. In the international sense, these are the rules for the Court of Arbitration for Sport, which my students from law and sport will be familiar with. Rule 57 is completely different in the international sense than anything we would be familiar with in the United States. International sport, like FIFA as an example, so that would be the other football that they play around the world. They're not collectively bargained. There is a union called FIFPro, which people may have heard of, but there's not a CBA between the players around the world and FIFA. It doesn't work like that. Instead, you'll have FIFA that will render a decision, or anybody underneath the umbrella of FIFA, which is pretty much anybody in the world. It could be a Brazilian Pro League, the English League, actually everyone except Major League Soccer, which is a topic for another day. They are collectively bargained and somehow managed to avoid these rules, and nobody really can understand why. But the international rule basically says everything is reviewable by a completely independent body called the Court of Arbitration for Sport, which is based in Lausanne. It's the Supreme Court for sports. And that rule, R57 of the CAS procedural rules, says the panel has full power to review the facts and the law. It may issue a new decision which replaces the decision challenged, or annul the decision and refer the case back to the previous instance. So it's a completely de novo review. They can have a new hearing, they can consider new evidence. There's no deference at all, necessarily, to the previous decision. So last year, does everybody remember the World Cup? There was a player named Luis Suarez, and he bit another player during the World Cup. He was suspended for a period of time. That decision was appealed all the way up to the Court of Arbitration for Sport, and ultimately the decision was lowered. One more thing, the case law does say we won't completely ignore a well-reasoned decision below. While we have the power to do so, if there's a well-reasoned decision below that lays out a suspension that makes sense, we're going to leave it alone.
So, Paul, do you foresee changes in the NFL's arbitration process as laid out by provisions of the collective bargaining agreement? And the next time it's bargained for, or if you were advising the NFL, would you advise them to use something more like the Court of Arbitration in sport, for example?
Well, at least to go to an NHL-style model, I would, because I don't know how many more times Commissioner Goodell can be humbled and wrapped in the side of the head. I mean, he's gotten 4 or 5 decisions overturned in federal district court in the last 2 years. At some point, he should get the memo. I don't know if that's going to happen, but the new NHL CBA is a lot different than the old one. So Don Fehr came in as a very powerful head of the National Hockey League Players Association and was able to negotiate greater rights for athletes in disciplinary cases than they had in the past. And I do think the NFL Players Association needs a powerful leader to come in and stand up to the NFL, because that is probably the weakest of the 4 professional unions. And for years, the NFL has really ruled the roost in those collective bargaining negotiations.
Thank you. So, Anne, given your experience in the collective bargaining arena, how did the arbitration process used by the NFL here, how does that differ from what's typical in labor arbitration, including under a collective bargaining agreement that you've encountered?
Well, I'm actually sort of, it's interesting what Paul said, that even within the world of professional sports, what the NFL has is really unique. Because certainly within the world of CBAs, labor contracts that I've experienced, it's very unique. Every arbitration, once you have a grievance that's been filed, it goes up through the grievance process, and then ultimately the union typically decides to bring it to arbitration. It's always a neutral arbitrator who is decided on, who is agreed upon by both parties. So either at the time the arbitration is filed, the 2 parties say, hey, here's my list of folks. The other side will strike a few and say, here's some more I'd like to add. And through that process, they come up with somebody who's hopefully available to decide the case, who's truly a neutral. In some cases, it's actually a list that's negotiated during the collective bargaining, during the negotiation process. And it's a standing list that you go down through. Next arbitration, all right, who's next on the list? Right, so it's a collectively bargained list of people, neutral arbitrator that the parties agree on. There are a number of interesting things about this whole process that are quite different than what I've experienced and how I advise my clients. Even though, technically I represent the NFL, I represent management side of the house, but throughout the whole process that played out after January 18th, the NFL really sort of missed the ball, I think. No pun intended. really did miss it at many different steps throughout the process. And if I can, I'd just like to sort of walk through how you ultimately get to an arbitration typically, and where I think there are some really discrete steps that they missed. First there's the violation, right? There's the conduct or the event that occurs that the manager, your manager, the commissioner, whoever it may be, town manager, city councilor says, or department head, whoever it is, says we need to discipline for this infraction. There was a problem here, we need to take action. So they either decide to do an investigation, or they say, no, we've got enough evidence. Typically what happens is you say, you give them sort of a pre-disciplinary notice. And it's not just this notice that's out there hanging, like it was sort of in the NFL, to say, you could be, violating this if you, whatever the conduct detrimental to the integrity of the game, right? And it really has to be explicit notice. You have to say to the person, for XYZ violation, all right, you have the opportunity to come into this pre-disciplinary hearing, okay, hearing is used sort of very loosely, and have your opportunity to tell us what happened. And it's really more of an actual notice. It's not this sort of, oh yeah, it's in the bargaining, you got this policy, right? You got this policy, that's notice enough. No, it's come in, tell us what happened. You're on notice right now that you could be disciplined up to including termination for this violation. All right, so that's a key point in this process that I think the NFL sort of diverted from. And at every step, I think they could have remedied. I mean, they really could have done it right, and maybe we wouldn't be up here talking today. But then typically what happens is you have that notice, the manager makes a decision, discipline action is taken, and then you go through the grievance steps and eventually to arbitration. So, you know, I think that there are, during the arbitration process itself, and I think James alluded to this a little bit in terms of the motions that were filed with Commissioner Goodell. You know, I think Commissioner Goodell, he had the opportunity here to nominate someone else in his place, right? And I think he should have done that, because Vincent's letter says, the commissioner said that a 4-game suspension was appropriate in this case. I mean, it's right there in the letter. So clearly he's already made a decision about how he thinks about this case. Yep, I agree, 4-game suspension, it's right there. Right, so that's another step in the process. He had the opportunity at that point to say, okay, you know, maybe I'm not the best person to hear this case. I have the opportunity under the collective bargaining agreement to designate someone else. Maybe I'll do that. Then we come to the actual arbitration, right? In the motion, there was a motion to compel a witness to testify, a motion to compel evidence, a number of motions, all of which Commissioner Goodell denied. And so, you know, my experience, and I know Mike can speak to this as well, my experience with arbitrators is that they tend to take in more evidence than maybe they need, and then make a ruling on relevance, or for instance, I think the issue with Pash was, oh, it's just going to be cumulative, because Wells already is going to testify, it's just going to be cumulative. Let the arbitrator make that decision. Bring it in, though. Make it fair. So my opinion of this, and even coming from the management side of the house, is that there were several steps that, had the commissioner made different, a different decision, I think it could have turned out very differently here.
Did you also want to comment on the investigation that was done, the Wells report, which Judge Berman talks about, and independent investigation?
I can talk about that now. Investigations are used a lot in my world, employment and labor, and I will say that it truly was, in my words, independent, as Berman couched it throughout his decision. I mean, throughout his decision, he puts independent in quotations. This whole case, for me, and I think the investigation included, is sort of, okay, we have an opportunity here to go this way or to go this way. And in every opportunity, even in the investigation, the way that the decision that they come in up, that they ultimately make, is really away from Brady and the Patriots. It's a lot of words like generally aware, plausible. I mean, there's a lot of these interpretations that the Wells makes, right? There are all sorts of plausible interpretations, but every single one of them is really in favor of the NFL and against Brady and the Patriots. Every single one. And maybe I'm starting to put my Patriots hat on a little bit more there, but really I think if you read the report, it's every single time he has to make a judgment call, that Wells, as the independent investigator, has to make a judgment call. He always veers in sort of the same direction, and it's a really interesting investigation. Investigations play a really important role in labor disputes and employment disputes, but you really truly need to make sure that they are isolated and independent from who's ultimately going to be making the decision here. And I think that in this case it wasn't, particularly as you start climbing up through the steps, and the person who actually defended the NFL in the case before Berman, you know, was a member of the litigation team. That it's all sorts of investigation team. So all sorts of, including within the report, all sorts of opportunities the NFL had to say, well, let's be fair, let's really look at this, you know, neutrally, and they really didn't, in my opinion. And this investigation I was shocked that Pash, or the attorney who represented the NFL at the Second Circuit had all the materials, had all the underlying materials, yet that was something that the commissioner did not offer up for the other side. It just seems that something about that is fundamentally unfair. But I know we only have time, so I don't want to dominate.
So we've heard a lot about the particular features of this process and perhaps some flaws or deficiencies in the NFL's process. But a lot of commentators have said, well, so what? This was part of a negotiated for agreement. So is the fact that that the NFL and the Players Association negotiated for this system with the opportunity for Roger Goodell to serve as the arbitrator, does that cure these flaws?
It could, because that happens all the time. Almost all the arbitration awards that I issue in discipline cases, I hear Denovo, what you referred to. This case is set up as a review of an investigation by the commissioner. So there's no independent evidence being produced to convince Goodell. He just relies on the investigation report. Management can work for language, and it's worth pointing out that all other types of disputes under this NFL contract do have neutral arbitrators set up for them. There's an injury arbitrator, there's a non-injury arbitrator. This is the only one. Oh, even the clubs can issue discipline of players, and they go to a neutral arbitrator. But if the commissioner issues discipline, he overrules and makes anything the club did irrelevant. So this provision, and glad you pointed out the interesting history to it as to where obviously the NFL was reluctant to give up control, and that's what happens once you go to a neutral, like myself. You give up control over the outcome. You still have to abide by certain rules, and when you appoint yourself as the hearing officer or as the arbitrator, and you've already made the decision, it's fundamentally a flawed system. So I think they went too far here. Management can often restrict discovery. Restrict the number. There's a lot of things that they can do to restrict the union's ability to kind of win an arbitration case by negotiating language. Why the NFL Players Association agreed to this provision? You look at that contract, it's 318 pages long or something like that. They've got all sorts of great language about all the money they get paid and all the rules and so on. And I think at some point they were willing to strike over these things. They weren't willing to strike over this. Next time, maybe another story.
Yeah. Well, would you say that Tom Brady's arbitration ends up being a win for arbitration? Because what happened subsequently was that the grounds for judicial review, as narrow as they are, actually operated here as they are supposed to do. The arbitrator made some errors, at least in the view of Judge Berman, and the award was vacated.
Well, I think the award of the judge is a win for arbitration. Goodell's arbitration decision was not, but what it did was expose the fundamental flaw in a process where you are both the prosecutor and the judge. And that's basically it. And I think the judge was very clever because the evident partiality issue is not only evident from the evidence and Goodell's statements, but it's fundamental in the setup to have the judge be the prosecutor.
And so why would the judge say he was not reaching that issue? That's another ground.
This is my take on that. He found 3 reasons, and he couldn't have laid the case out for evident impartiality more than he did with all the supposedly independent investigation and all the other things that showed there was partiality on the part of Goodell. But by leaving that open, it forces the Second Circuit to either accept it as it is now or send it back, it seems to me, for that, which is clearly a winner, in my opinion, for the union. So he's really holding the NFL's feet to the fire and making it tough on the circuit court.
So do you want to speak to the significance of the exclusion of testimony or the the rulings on the discovery motions that
Well,
Ian mentioned, and whether these really did deprive the process of fundamental fairness?
The problem is this is such an unusual case. All the discipline cases I do, and I venture to say that Anne has done, involve just cause for discipline. And that's all the term you have, just cause for discipline. So that doesn't appear here. In fact, he doesn't even refer to himself as an arbitrator. He views it as a hearing officer who has no standard. Now, in the decision, he says, well, of course I'm bound to be fair and objective. He says that in his own decision.
Yeah.
That's not in the contract. That kind of qualifies in the kind of unwritten rules about due process that stem from the Constitution, that have worked their way in over the years into labor arbitration. So much so that it's really part of what just cause is. And you have to have due process, and that's where notice comes, opportunity to be heard, a fair investigation, and things like that. So it's very unusual. I forgot your question though. And now, by the way, I am not pretending to be neutral. I am pretending to be neutral because I'm a professional neutral. And one of the things that a neutral arbitrator does is make sure that he listens to each side and has opinions that are accepted over the years. You don't get assigned to be an arbitrator. The parties always pick you. And so if you say things like supervisors never lie in your decision, or, grievance, this guy was, underpaid and therefore he was, you make some sort of biased statement, you would never do an arbitration again.
So crossed off that list.
Yeah. So.
Okay, good. Well, we want to be sure and...
I did want to comment on why a union would want to have grievance arbitration. It's because grievance arbitration is designed to keep you out of courts, get a quick decision from an expert. And that's referenced in the, all these terms, draw the essence and own form of industrial justice, come from 3 Supreme Court cases in 1960 called the Steelworkers Trilogy. And the reason why unions they want a quick dispute, they want a quick resolution to a dispute at the courts, and they want it by an expert, not by a judge who doesn't know anything about labor law. An interesting thing is an employment lawyer in Maine, a management employer, recently wondered, why does an employer agree to grievance arbitration? And the answer is that it's usually in return for a no-strike provision. So there's a no-strike provision in this collective bargaining agreement, and if that would be the trade-off for if there was no grievance arbitration, and there are some contracts, particularly in the construction field, where there is not a no-strike provision, and if there's an issue that's important enough because it's a very short life on a construction project, they can go on strike. And employers want grievance arbitration proceedings as a way to stabilize the work process.
So both sides have an interest.
Both sides have an interest in having this.
And we would have to agree that this was a relatively speedy process because the arbitration happened in
That's right.
June. There was a decision, and then there was a decision by the federal district court judge in early September.
Right. Very speedy.
It was very speedy. Yeah.
Okay, so there was some efficiency and speed achieved there. Well, thank you, Mike. So questions from the audience here?
Can I just add one thing about Janice Turner before we do that? It's an advertisement for this law school too, and I know he has a house in Prouts next, so maybe he can go to night school here. But he's not a lawyer, and most of the other commissioners are, and I think it's pretty interesting that he just doesn't have a fundamental understanding of due process or anything else because he never went to law school.
Despite having the best lawyers that money can buy to advise him.
Yeah.
Right, and I think that he just fell on his own sword by failing to understand his own limitations.
Questions? Yes, Jason?
Does the NFL have a legitimate chance when they try to besmirch Gray's name again in the spring? Because they agreed to wait until after the Super Bowl this time. And so after...
Well, the Second Circuit will hear the case.
I think the Second Circuit will overturn it. Sustain the judge. And that'll be the end of the case.
On what basis?
On the grounds that, particularly the first ground he cited, where the inadequate notice. And he cited about 5 or 6 grounds. All they have to do is find one, really, to sustain it. I'm not sure I agree with all of his decisions on what's acceptable and what isn't. But I think they'll overturn it. And if you want to.
In other words, they'll uphold the
Excuse me, they'll uphold Judge
in
Berman.
vacating the
Right, because as
arbitration decision.
one of you guys said, the courts opposed arbitration for many years when it first started. But then they realized that this would keep work out of the court system, and at some point that came into play. First they thought it was taking their jurisdiction away. Now they see that it's taking their caseload away. So they're all in favor of deferring to arbitration. And so the more you meddle, I mean, that's what the Steelworkers Trilogy said. Don't meddle in these things. Don't do that.
It's very rare for a circuit court to overturn a district court.
Well, it's actually somewhat rare for a district court to vacate an arbitration decision.
That's true.
I've read that that happens in approximately 10% of cases.
And I would say that
nationwide.
I mean, I'm going just from my memory when I interned with Judge Lopez, but I think that the standard in the First Circuit was similar to that it's about 90% affirmed. So I think that the odds are way with an affirmation of Judge Berman.
I've only been overturned once.
So, since you asked this question, let's just go down the row here and put the panel members on record, as they do on game day. What are the other 3 of you, what are your predictions for the Second Circuit? Ann?
I agree with Mike.
So all 3 of you think the Second Circuit's going to uphold the district court?
The experts have spoken.
Well, okay, so
I'm gonna go with their pick.
all right. So Trevor, I happen to
Be the contrarian, Trevor.
we happen to have discussed this in our ADR class last night. So I happen to know. I have a little hint here of where you're going to go with this.
Sure, so I'll preface this by saying I'm not an expert. Patriots 30, Bills 23. No. And it may very well be, as Paul was saying, that circuit courts just don't do this. I'm wondering what the importance of, or what the court will view as constructive notice that Tom Brady could be suspended for his role. So if they accept the Wells report's findings as true, which Judge Berman did, then I'm wondering if the court will find that the NFL Constitution and bylaws says that a player can be suspended for conduct detrimental, which in the opinion, judged by the opinion of the commissioner, the player contract, which is distributed to every player in the NFL, which includes very similar language, as well as Article 46, again, which gives this enormous power to the commissioner. So I'm wondering what the effect of, or what the what the judge will think of the NFL's argument that Brady had constructive notice, that providing financial inducements to support staff to deflate footballs, he would have noticed that those actions would constitute what the commissioner would claim is conduct detrimental. So I think that's something to look at, and also the fact that, and Mike spoke to this as well, is the NFLPA gave all of these rights away to the commissioner. And I think that that's something that's not being understood. The average career for an NFL player is around 3 years. And we were talking earlier about how the NFL CBA is so different from other sports collective bargaining agreements. That's a big part of it, because the players know that if they don't get theirs while they can, the owners can much more afford to hold out than the players can in a lot of respects. So I'm curious what the court will make of the fact that the NFLPA didn't push for discovery rules, tighter discovery rules, and lesser power for the commissioner. So I'm not going to argue with the experts because I'm in no position to, but those are the issues that I find fascinating for the Second Circuit.
Great, thank you. Other questions?
I'd like to address the, oh, go ahead.
Is it legal for Justice Berman to collect his free coffee for life?
I'm not sure what you're referring to.
Is it
Technical? Oh, that's
Free
right.
coffee for life.
That's right.
There's terms in there that referenced by the judge called the law of the shop.
Yeah, and drawing from essence, the essence of the agreement.
Well, the essence, I wanted to talk about the law of the shop, but there's a Supreme Court decision that lays out draws the essence from, and the own brand of industrial justice. These come right out of U.S. Supreme Court decisions. But the law of the shop is what distinguishes any run-of-the-mill contract from a labor relations contract. And because the Supreme Court saw that it's actually a governing document for a whole industry, a large company and all their employees, it's different than contract. So what the Supreme Court said is you have to consider as part of the law of the shop of this contract, the collective bargaining history, which is usually excluded under the parole evidence rule under contracts. But here, no, the collective bargaining history is important. Past practice is important and relevant. Industrial practice, not even the practice at this company, but the practice in the industry is relevant. Prior arbitration awards are relevant. And other extrinsic evidence of meaning are all relevant in a labor arbitration that are not in a typical arbitration. So when the judge says law of the shop, he might have been referring to the Ray Rice decision by another arbitrator under the language, or the Deflategate decision. So that law of the shop really distinguishes a contract, regular contract, from a labor collective bargaining.
Thank you. Other questions? Any closing comments here, panelists?
Yeah, I'll make a prediction, sort of like Trevor's. I think that you're going to see shortly in the NFL's player conduct policy, because that's a unilateral thing given by clubs, so that doesn't have to be bargained for, anything in the policy. I would be shocked if we don't see that tampering with game balls isn't thrown on there.
As a specific requirement.
Because after Ray Rice and Greg Hardy and all those domestic dispute cases, the first thing they did was update that policy so it's specifically on point. And I think if they do that with tampering with game balls, that's going to clear up the notice issue at least.
Well, I just take issue with one thing you said, is that they don't have to negotiate that. They do.
I thought
Any rule that pertains to employee conduct is either negotiated or it's not as forceful as if it's part of the collective bargaining.
Okay.
And that was a big point that they made about the competitive integrity policy that was given to the clubs, the managers, and not expressly given to the players, and that was nor incorporated into the collective bargaining agreement. And so, as Mike said, anytime you have a policy that impacts players, it either has to be negotiated or it has lesser weight. So.
And one thing maybe that's a signal for what's to come. The NFL for years refused to have anti-doping cases be handled by outside third-party neutrals, and they finally yielded on that issue. And this year, anti-doping matters are now being handled by an outside arbitrator within the NFL. And they were the last league to go to that model too.
And you've got to think that after this experience, the owners who will be at the table next time around have to think about giving their commissioner the kind of power that they've given to Goodell. And just, as you pointed out, he just loses in big cases over and over again. So, and the Players Association are kind of now embarrassed about the fact, why did you give this power away when nobody else does? So I think we'll see definitely a new collective bargaining agreement on this.
Can I ask a quick question?
Sure.
This year, the NFL started now monitoring the air pressure balls before the game, and in the middle of the game, and after the game, in light of all of this stuff. But we haven't seen any of those test results. Do you think we'll ever see those test results, or do you think if we do, it's going to be after the second circuit?
Somebody will leak it.
I'm sure the situation will never happen again.
All right, well, stay tuned for further action, and thank you.